So normally when I've talked to the conference, I've talked very much in detail about what the expectations are of members in terms of their obligations to do with the Code of Conduct. But very recently, January 2019, we published the new revised Code of Conduct and an introduction into the powers of the institution to investigate fitness to practice through ill or failing health. And I thought that would be relevant and important to be able to talk to you about that today. If we just have a look a little bit at the background in terms of the Code of Conduct, the last time it was changed was back in 2014. It does take quite a long time to undertake a review, I have to say, not just because it's the institution. I think these things do take a long time anyway. In 2016-17, the institution's ethics panel adopted the Royal Academy of Engineering and the Engineering Council's Statement of Ethical Principles, which incorporate honesty and integrity, respect for life, law, the environment and public good, accuracy and rigour, leadership and communication. As an institution, when we've always referred to the Code of Conduct as in terms of dealing with our members' ethical behaviour, but whilst there's quite considerable crossover between ethical behaviour and professional standards, there are some distinctions, and I think a lot of the time people might consider ethics to refer to a judgment, and where the Code of Conduct actually refers more to professional actions themselves. But within each of the sections adopted by the ethics panel, there are requirements which relate to both judgment and professional action, so there is very much a crossover. And then, in January 2019, we revised the code and the associated regulations. It did take us a period of 2 years, and those were then published. And at that point, as soon as they're published, they become an obligation placed on the members. The actual articles of the Code of Conduct still remains 8 of them, and actually they haven't changed a massive amount other than to incorporate an explicit requirement for members to act in accordance with the principles of ethical behaviour. And those changes are further detailed in the guidance notes, where there is an express requirement in those notes for members to comply with the Statement of Ethical Principles, which is what we talked about before. The only other change was the minor but significant change to only accept those appointments as well as to undertake those tasks. So the changes are highlighted in green. Up to the newly published Code of Conduct, there was simply a requirement, in addition to the 8 articles, for members to disclose whether they had been convicted of a criminal offence. As you can see, the changes and the amendments or additions are more extensive in terms of what we now require you as members to do. We'll go through them individually, but up until 2019, actually many of these items were implicitly referred to in terms of the guidance notes, and very often our members would routinely inform us of, in particular, if there had been, unfortunately, a bankruptcy or a disqualification as a company director. But what we recognise in doing the review is that there are set expectations of our members and other people in positions of professional standing, which dictates a need to explicitly define that these particular expectations are actually obligations of membership of the institution. The first one, it relates to the fact that our members operate globally, and there's an obligation to ensure that one is cognizant of the laws and local jurisdictions in the place that you are working. Again, it does happen, unfortunately, being made bankrupt or being disqualified as a company director doesn't necessarily of itself mean that there has been a breach of the Code of Conduct, But sometimes there are actions which happen thereafter which give rise to allegations and result in complaints to the institution. There is an obligation, as there always has been, to disclose to the institution if you've been convicted of a criminal offence. And this one always throws up lots of discussion as to, what constitutes a relevant criminal offence. In actual fact, the relevance of the criminal offence, other than where the PCC have now qualified that motoring offences not resulting in disqualification don't count, it is a role of the Professional Conduct Committee to determine what the relevance of that criminal offence is. If I can give you a couple of examples, in my time here, there aren't that many, fortunately. We don't have that, well, there aren't that many that are reported to us, but we had a member of the institution who was a director and an owner of a nursing home, vulnerable people. And he was convicted of negligence in terms of the vulnerable people within the nursing home, and his conviction resulted in an expulsion from the institution. We had another member who was convicted of assault, and that was reported to the institution, and he was subject to a different sanction. He wasn't expelled from the institution because the Professional Conduct Committee will consider all of the circumstances. So whilst a criminal offence doesn't automatically mean expulsion, it does require an automatic report to the PCC. Disclosing to the institution an adverse finding before any tribunal, court or other competent authority relevant to the membership of the institution, that relevance is very often, you have to ask yourself whether it brings the reputation of the profession into disrepute. That's generally where that comes from. And the last one, there was a need to explicitly include that because we were having an awful lot of our members who didn't comply with, well, not an awful lot, but a significant proportion who didn't comply with either the procedures associated with the disciplinary process or indeed comply with any sanctions imposed by either the Professional Conduct Committee or the Disciplinary Board. Thought it might be useful to just remind ourselves what constitutes the laws of the institution. It's basically everything. Everything that's written down at any point by the institution constitutes a law. It's the Charter, the bylaws and the regulations. But then bylaw 9 requires members obliged at all times to uphold the reputation of their profession and to observe the laws of the institution as defined by bylaw 1E. And therefore, the guidance notes, the disciplinary rules, the code of conduct, everything that we have essentially which places an obligation on the member is considered to be a law of the institution. If we look at what the expectations of both of our, the institution on its members, but what the clients will expect from you, it is their reasonable expectations that are placed on you is that you are competent, having had your competence measured by the membership application process, that you've met particular qualifying standards as indicated by your membership grade, that you adhere to codes of professional and ethical conduct, that you will be professional in all of your professional activities, and that you'll deliver a quality service throughout the appointment. And if things don't go to plan, that you will have in place good communication and support for your client in order to resolve any situation that does occur. It does remain the case that the vast majority of complaints that come through to the institution are as a result of poor communication, predominantly in respect of fees. We also see quite a lot in terms of mismanaging the expectations of the client in terms of their project and generally poor business practice. Less so, we have complaints arising out of allegations to do with technical incompetence, but over the last couple of years we are seeing those types of results, those types of complaints increasing. So that was the changes predominantly to the actual code of conduct. We also introduced quite significant changes to regulation section 4, which is the section of the regulations which deals with the disciplinary process and the powers of the Professional Conduct Committee and also to the disciplinary board. The changes that we undertook mainly to bring them up to date with current best practice, and also some changes in disciplinary laws and precedences that had been set. But also some of the changes, and one of the most significant changes, which is to do with the fitness to practice, was introduced as a result of common themes and scenarios that were not particularly well addressed by the regulations and procedures that we have at the moment. This is one of the significant changes to the regulations. It isn't to do with fitness to practice, but I thought it was important that you should know. At the moment, previously, the PCC could sanction a member with 3 consecutive suspensions for non-compliance of a decision or non-compliance with a procedure. Now, they can, after 3 consecutive suspensions, they can now invoke the sanctions of the disciplinary board, which could be a suspension for up to a period of up to 5 years, or even permanent expulsion. We've had too many complaints that go through to the disciplinary board, which are of our members not complying with decisions of the Professional Conduct Committee. And when that's happened, it's taken very seriously by the disciplinary board and very often does end in a lengthy suspension. I think the longest has been 4 years, but also in permanent expulsion. And this is the new regulation with regards to fitness to practice. And it's to investigate and adjudicate on any matter brought to the attention of the institution concerning a member's fitness to practice, in accordance with the PCC's constitution and procedures. Lots of other organisations refer to fitness to practice in terms of everything, in terms of their competence, professional standing, and the health of the individual, which enables them to fulfil their role. The institution separated that out, and when we talk about fitness to practice now, we're only talking about the health of the member, because everything else is dealt with in terms of the code of conduct. And one of the reasons for separating it out is so that we can actually undertake a confidential and sensitive investigation in terms of a member's failing health or illness, and we can separate that from any investigation which is concerned with a complaint against their competency or professional conduct. The reason for doing it, there's 2 reasons for doing it really. One, we are a charity, we have charitable objectives, we have charitable objectives towards the public benefit, and we have a responsibility both to the public through our members and also to our members themselves. Specific to talking to yourselves as small practitioners, there are specific vulnerabilities to this particular sector. Very often, this is in terms of the complaint process in general, the absence of an internal complaint process. Complaint processes can be quite a huge administrative burden. But particular to the fitness to practice new regulations, there is a vulnerability with regards to illness and extended periods of leave in the small and sole practitioner sector. No one is at all surprised that many of our members in those sectors, yourselves included, will continue to provide services through a period of illness, whether that's long-term illness or short-term. So, what will it look like? I mean, these are very sensitive times, and particularly for a member who is already ill or is suspected to be ill, and that's one of the PCC will be able to start off an investigation under 2 circumstances really. One, the member declares an illness as a mitigating factor in terms of why they could or couldn't comply with the code of conduct, or could or couldn't comply with the decision of the PCC or the disciplinary board. But in addition to that, sometimes when the PCC are undertaking an investigation, it becomes quite apparent through the information that they receive, predominantly from the member, that there may be an underlying health reason why the situation has occurred. So once they start that confidential investigation, this is essentially what it would look like. We would first inform the member that it was conducting that investigation, and importantly of its concerns causing it to do so, and the member would of course be invited to provide the PCC with representations as to those concerns. PCC would then decide whether a medical examination or assessment of the member was required, but importantly, very importantly, the complainant wouldn't be provided obviously with any of the information pertaining to that investigation through fitness to practice. And at that point at which that investigation starts, the complaint, which gave rise to the original investigation, would be suspended. In the event that the PCC decided that the member's state of health prevents or hinders the ability to fulfil the professional obligations, and it's really important to re-emphasise that, because that's the only thing that the PCC would be looking for in this particular investigation. Does the outcome of the investigation indicate that the member's health prevents their ability to fulfil their professional obligations as a member? They have a number of options available to them. You'll note none of them are sanctions, not in the same way that it would be a disciplinary sanction. So they can provide guidance to the member. They could require evidence of continuing medical assessment or treatment, require the member to provide and abide by undertakings, and those undertakings can be described in any way which the PCC thinks is relevant. They can suspend the membership of the institution for a period of up to 12 months, and then further suspend for another period of 12 months, subject to any outcomes of medical assessments during that time, or they could suspend the membership indefinitely. Keeping all of this in context, we have over 30,000 members in the institution. The PCC deals with 35 cases a year on average. And in 2018, unfortunately, complaints against small practitioners were in the order of 90% of those complaints. That's not to say that small practitioners are more likely to not comply with their obligations as a member of the institution. It comes back to the vulnerability side of things, where if somebody has a complaint against one of our members in a large organisation, then they're much more likely to go through the process of the large organisation rather than through the complaints process of the institution. When complaints do come through, this is relative to 2018, 85% of those were upheld fully or in part, with 94% as a minor breach and only 6% of those being referred through to the disciplinary board. And of course it's 6% of 35, so it's not very many cases that go through. And in terms of if we took those complaints from 2018, there would probably only be 2 or 3 of those that would have necessitated an investigation under the new regulations to do with fitness to practice. There is a lot of support available for our members, both through the Code of Conduct and Guidance Notes. Is not intended to be a document to bash around the head with. There are the guidance notes themselves are intended to be helpful. The Statement of Ethics, which we've referred to before. The institution's Business Practice Committee produces a very well-received set of business practice notes, and they deal with all manner of different things, from fee structure, contractual guidance notes on how to set up proper contracts, all various different things. Myself and Ross Poulton, always available either by telephone or by email. And we also have the institution's benevolent fund, which is set up basically to assist our members and previous members of the institution when they are in positions of difficulty, be it financial or health-wise. But I'm going to talk about that a little bit later.